online. So that will be an option. And of course, you can always go to your own attorney to get training. After your first training, you have to get training again at least once every 2 years. And the clerk of the public body must keep the records of the training, including your name and date of the training, for 5 years. However, please note, there is no requirement to report your training to us at the FOIA Council. You don't have to report it to VACo when you do a training like this through VACo. You just have to keep your own records with your clerk. All right, continuing. This is an older requirement. This has actually been in the law for quite some time. On 2.2-3702, that all elected, re-elected, appointed, and reappointed officials receive a copy of FOIA, read it, and become familiar with it within 2 weeks of their election, re-election, appointment, or reappointment. You can always get a current copy of FOIA on the FOIA Council website if you need one. But keep in mind, FOIA is about a 60-page law, so it's going to be pretty long. Let's see. I see in chat there's a request there to get the certificate and PDF. I would ask if, John, if you're listening, I know you had those links that you posted earlier in the chat. Maybe if you could repeat those for them. Or actually, well, I see them up there. Let's see. I think I can just cut and paste it. Let's see. This one, I believe, is, that's the certificate link. And then right above that, there it is. Cut and paste. There's the link for the PDF version. Okay. Moving on. One thing I'd like to remind everybody, you call us, I am a lawyer, I'm happy to talk about the law, but based on our statutory provisions, as Executive Director of the FOIA Council, I have authority to give guidance and advisory opinions on FOIA. I do not have any authority to advise you or make interpretations of other laws. So for that reason, there will be times when I'm going to have to tell you, here's another law, here's what it says on paper, and sometimes I will have heard multiple interpretations of it. And if that's the case, I'll tell you so, but I'll tell you, you need to consult your own attorney to get advice on what to actually do with it. Some examples of those for the court clerks, there are numerous rules about court records out in Title 16.1 and 17.1. There's also the rules of the Supreme Court of Virginia address that. For local, let's see, I have an annotation request here, and technically I do not know what I'm supposed to do with that. I think Phyllis or John, I don't know if that's something I should approve or decline on a request to annotate shared content. I think I'm going to decline, not hearing otherwise, just for now.
Yeah, why don't you do that, and we can take care of anything that anybody needs after I finish the presentation. Okay,
thank you, Phyllis. Okay, so the ones probably of most interest to the people here today, we went too far. 15.2-1415 through 15.2-1421 are the specific laws for meetings of local governing bodies. The laws specific to city councils, town councils, and county boards of supervisors. There's numerous other provisions in Title 15.2 talking about things like public hearings, certain public notice requirements, and those are separate from FOIA. Often they kind of overlap or they're in addition to, but when you have questions about interpreting Title 15.2, I'm going to almost always tell you you need to speak with your own attorney or contact somebody like Phyllis at VACo. Similarly, there's provisions for school boards, and I'll tell people to talk to their attorneys or go to the VSBA. And the last one is a tax code provision. This actually pretty much applies to everybody. I mentioned it specifically as an example of a prohibition that says you cannot release certain records. And because we do this training for, of course, commissioners of the revenue and treasurers who are going to be affected by this on a day-to-day basis. Okay. Next, getting into the nuts and bolts about public records. The main purpose of this, we're going to talk procedure because FOIA is a procedural law, but for the most part, especially for elected officials, usually you have some staffers helping you out handling most day-to-day nuts and bolts stuff. So we're actually going to go super deep unless you have questions about it. We're going to start by reminding everybody all public records are presumed open unless they're specifically made exempt. This is part of the policy statement. And I'd keep in mind, just it's right there in the name of it. When we say public records, these records belong to the public. Yeah, we may have created them, we may have made them, but we're doing it because we're doing work for the public. And everything we're doing, as it said in that beginning statement, is for the benefit of the people of the Commonwealth. So when we're creating records as part of our jobs, either as for me as a state employee or for you as an elected official, that's something we're doing not just for ourselves, that's for the public. So the definition of public record, again, reflecting that FOIA is to be construed liberally in favor of openness. This is a very broad definition. It includes all writings and recordings consisting of letters, words, numbers, their equivalent, however stored, regardless of physical form or characteristics. If you actually look at the code section, you'll see there is a long laundry list where I put the 3 dot ellipses there. Basically, it's any type of record. We have typewriting, printing, photostating, handwriting, photography, magnetic impulse, etc., etc. It doesn't matter if it's a videotape, if it's an audio cassette, if it's a digital file, if it's a handwritten letter, any type of record is what we're getting at with that first bullet point. But keep in mind, FOIA applies to records. FOIA does not apply to general, conversations, for example, where there's no recording. It doesn't apply to interviews or requests just to answer a question that's not in the form of a record. FOIA does apply to records. So we talk about the consequence of choice. When you, for example, need to talk to a fellow official or say one of your employees at your locality and you send them an email, that's fine. There's nothing wrong with that. But keep in mind the consequence of that choice, you've created a record. Now, if it meets the next part, prepared, owned by, in the possession of a public body, its officers, employees, or agents, and in the transaction of public business, then it is a public record. As a public record, it's probably subject to FOIA, maybe subject to disclosure, unless it's exempt. And also there's the Public Records Act, which covers record retention. So anytime you send an email that's about public business, keep in mind there are going to be rules that apply to it. This also applies to text messages, social media posts, just about anything where a record is created. You want to keep in mind, again, it's not good or bad, right or wrong. This isn't a moral choice or anything. It's just the consequence of choosing to put something in a record form. It may be subject to FOIA and there may be retention rules on it. Also, notice in this definition, we do not have an exception for drafts. Some versions of FOIA in other states, for example, may say that drafts are excluded. Virginia's FOIA does not. So a draft version of a record, a preliminary version, can still be a public record. Now, I see in chat there's a question about, is a text message a public record? Sure. Any type of record, if it meets this definition, can be a public record, whether it's text, Facebook posts, Twitter posts, almost anything like that. I can tell you Facebook, Twitter, other social media has been a source of litigation, both at the federal level and throughout various states. There have been a number of different rulings. For FOIA purposes, though, it's generally pretty simple in that we look at this definition and say, okay, is it a post made, prepared or owned by, or in the possession of the public body, its officers, employees, or agents? So as public officials or public employees, did we do it, and did we do it for the transaction of public business? If the answer to those questions is yes, then it's going to be a public record. Now, also keep in mind, just because something's a public record that meets this definition does not always mean you have to disclose it. That is the general rule. That is the policy of FOIA, except when there is an exemption or a prohibition. If there's an exemption, then you do not have to disclose it. And if there's a prohibition, then you cannot disclose it. You're not allowed to. So those are things to keep in mind. And I talk about this later, but I'll mention it now. I talk about kind of a funnel analogy where at the top level, we're looking at, okay, all the records we've got, and then which ones are going to be actual public records that meet this definition. From there, if you get a FOIA request, you got to sort through that to say, okay, which one of these are responsive to the request? And then you look at, are these things exempt or prohibited from release? And that whole process, you're narrowing down your scope of what records you're dealing with. And at the very end, you've got public records that respond to a request that are not exempt or prohibited from release. And those are the ones you give out. Okay. Few FOIA myths, and a lot of these come from the name Freedom of Information Act. I already mentioned FOIA addresses access to public records. It's not just about information. You will see the word information used throughout FOIA. We had a legislative change a few years back in response to a court case, just to clarify some of the redaction rules. And even though it says information, keep in mind that is a defined term. and it specifically means information contained in a public record, particularly in the exemption sections of FOIA. So it's not just talking answers to questions, interviews, or explanations. It is talking about information contained in a public record. The next, inspector copy. This is about a requester's rights because it's the requester's choice whether to inspect records or to get copies of them. It's always their decision. There are some other laws, I'll tell you, outside of FOIA that may say something like this is open to public inspection, and those have been interpreted to mean that the person only has a right to inspect, not to necessarily get a copy. FOIA, the general rule is it's the requester's choice either way if they just want to look at records or if they want to make copies and take them with them. Next, freedom of information. A lot of people think, oh, that means it's all free. Well, it's not. Bodies are allowed to charge to produce public records. And this is where in a minute, when we talk about charges in more detail, I'll go back to that funnel analogy because you can charge for that whole process of narrowing things down and identifying which records get released. Also, keep in mind FOIA exemptions generally do not prohibit release. This is a thing that comes up periodically where people say, oh, that's exempt from FOIA. I can't release it. Technically, that's not correct. If it's exempt from FOIA, a lot of the time you still can release it. And this is because the FOIA exemptions have prefatory language where it says the following records are exempt from mandatory disclosure, but may be disclosed in the discretion of the custodian, unless otherwise prohibited by law. So when you have one of those exemptions, that means you do not have to release something, but you can within your discretion, unless there's a prohibition. And prohibitions are the one that says you shall not. You may not release these records. Some of the examples of that, there are only really two in FOIA. One concerns certain student information. The other is about the identity of people who are providing information about criminal activity and they've been promised anonymity. Those are the two prohibitions in FOIA. Outside of FOIA, you see things like social services records, tax records, criminal history. There are some provisions outside of FOIA that just say you shall not release these things. And so those would be the actual prohibitions. But in FOIA itself, there's something like 150 exemptions total. And those all are, you don't have to release it, but you can. Okay, and lastly, informal versus formal requests. There's no real difference in FOIA. FOIA says a requester does not have to mention FOIA in order for FOIA's rules to apply and time limits and everything. So it also doesn't have any rules about how to make a request, as far as they don't have to put it in writing, they don't have to use a particular form. So if someone just comes in and says, hey, can I see last month's meeting minutes? And they're a citizen of Virginia, technically that's a FOIA request right there. They don't have to do anything more than, hey, I'd like to get a look at these records. Really, we're going to talk a little more about what they have to do. But I have, every once in a while somebody says, oh, I'm calling you because I asked for these records and they said, oh, you need to call the FOIA council to make a formal FOIA request. Well, no, you don't. Number one, that's not part of the statutory requirements. You don't have to do that. Number two, just so everyone's clear, all the things we do at the FOIA council, we are not a records repository. We do not process requests for other public bodies. So if they come to me with their request, I'm going to just send them back to you. All right. So talking a little bit about who can make a request and how to make a request. So formally, it says citizens of the Commonwealth, representatives of newspapers, magazines, radio, and television stations that either have circulation in the Commonwealth or broadcast in or into the Commonwealth. This has been challenged all the way up to the U.S. Supreme Court in the case McBurney versus Young, and the U.S. Supreme Court was challenged on constitutional grounds, and they upheld our law. So the limitation does apply, which means technically, if somebody's from out of state makes a request to you, they don't have Virginia FOIA rights. However, we're going to go ahead and recommend that you respond anyway, because it's very easy for anyone who wants to go to muckrock.com or to hire FOIA professionals or go to one of any number of other sources where they can get a Virginia citizen to make the exact same request. Also, a lot of people, if they're interested enough to be making a request in Virginia when they're from out of state already, they probably know somebody here, whether it's a business partner, whether they've got a registered agent who's a lawyer in Virginia, whether it's a friend from college, somebody's cousin, whatever it might be. They probably already know someone, and they're not going to have too much trouble getting someone. So we recommend you go ahead and respond to them anyway. Keep in mind with this, while we recommend it as a best practice, it also it standardizes your internal practices for consistency. You don't actually have to follow FOIA strictly when you're dealing with an out-of-state requester because they technically don't have FOIA rights. So really, that's more of a contractual agreement. So things like the charging rules, the timing, and all those are usually the things we hear most about. You don't have to follow them strictly. If someone, say, from Idaho says, I need to get these records, and you say, well, I'm willing to do it because I know you can get somebody here, but I want you to pay me all the money up front. And it's going to take me 3 weeks instead of the usual 5 working days to respond. Well, that's an agreement you can make with them. And technically, you don't have to respond. So that's, doing them a favor in a way. And I think that's okay. All right. For how to make a request, the things that a requester has to do. First is, of course, they have to identify the records they want with reasonable specificity. When talking about that, we've always given it a practical standard. Can you tell what they want? I also remind people that volume is not an exemption. They can ask for as many records as they want. But at the same time, I'm going to note, I've seen some requests that it's not just that they're voluminous, it's that they're vague. And I would say they're not reasonably specific because they're just too general. I'll give you an example. I'll just say that it was someone who'd been in office for about 15 years, had someone come to them recently and say, yeah, I'd like to get all of your letters from your office during your term of office. And I said, what is that? What do you mean? All letters in the last 15 years? And that's like asking me for all of my papers or all of my records. It's just a general vague request and there's no specificity to it. So I think that's really not good enough in that case. On the other hand, we've had, and this is an example Maria had years ago, that was real. Somebody came in and said, I want every record you have that uses the term staff recommends, in quotes. That's going to be a tremendous volume of records at most places, but it is very specific. They're looking for anything that says staff recommends. They don't want things that don't say staff recommends. So you can tell what they want. Now, most requests are specific as to subject matter and often time period, but they can be vaguer than that, and they don't always have to identify the subject. I've seen things like, I want every report done in the last 2 years by a certain employee or from a certain department within a locality. Those can be specific enough, even though they don't identify the subject. Other requirements on the requester, the pub body, if you want to, you may require them to provide name and legal address. The law does say require, so we have interpreted that to mean if they refuse to provide name and legal address, then they have not made a valid request at that point, because the law says you can require it. Again, keep in mind, requests do not have to be in writing. They don't have to say FOIA. And also, their purpose does not matter. For any attorneys, this is Associated Tax Service versus, I think it's either Fitzgerald or Fitzpatrick. I think it was Fitzgerald from 1988, Virginia Supreme Court. They looked at a request it was for a commercial purpose in that case. They said it doesn't matter. We don't care why you're making the request. We're looking at, are you a citizen or media? And are the records exempt or required to be released? We don't care what you're going to do with them afterwards. FOIA doesn't look at that. I would say keep in mind that when something is exempt and you have discretion to release it, sometimes it is helpful for the person who wants the record to say, hey, I want it for whatever their purpose is, because sometimes that can sway you to use your discretion to release it. But at the same time, they don't have to state their purpose. That's really up to them. Lastly, we already mentioned this, but it's the requester's choice to inspect or to receive copies. All right, so having done that, transition over to what are the responsibilities on us in responding to a request. And this is where I like to hold up one hand and remind everybody, if you have 5 fingers on one hand, you have a FOIA cheat sheet built in right there, because it is 5 working days for your initial time limit to respond, and you've got 5 choices of responses because FOIA is a multiple choice test. So 5 working days after the request is received. So if you got your request today on Monday, day 1 would be Tuesday, tomorrow. Day 5 would be next Monday, the 23rd. You don't count weekends and legal holidays as a general rule, or other days the office is closed. For example, I know several years ago they had Snowmageddon up in Northern Virginia, and a lot of localities were completely closed. A lot of schools were closed. If your office is completely closed like that, it is not a working day. We're giving it, again, a practical interpretation. It's a day when people are working. And I missed this a little earlier, question about, so all text messages need to be archived. I'm going to jump over a little bit and tell you to call the Library of Virginia. Library of Virginia administers the Public Records Act, and they set all the retention schedules. And I can tell you, one of the examples I've used talking with some of their records retention people is, if you were running late to a meeting and you shot a text message over to your chair or to the clerk of your board, and you said, hey, I'm stuck in traffic, or hey, weather's bad, or whatever the reason is, running late, be there in 20 minutes or something like that. They would say that it does not rise to the level of something you need to keep. For my purposes for FOIA, well, it is about public business, so technically, yeah, it's a public record. If somebody happened to ask for that before it got deleted, I guess it'd be subject to FOIA and you'd turn it over. But they're going to tell you don't have to keep it, so you could just delete that right away. On the other hand, and text messages tend to be short, and they don't tend to be real deep on substance, but the record retention rules are everything from delete it when you're done with it all the way up to permanent retention. The more important the person is who's doing the thing, and the more substantive the work is, the more it has some sort of historical value, the more likely it is you're going to be on the high end going towards permanent retention. Things like board meeting minutes, those are usually preserved forever, is my understanding. If you had, your chair was doing a major policy proposal and wanted to send that out, that would probably be something you'd keep for some period of time. But on the other hand, hey, I'm running 20 minutes late on a text message, probably you don't have to keep that at all. All right, a couple other things on responding with the 5 working days. We're going to talk timing when we get to all the responses, but I want to remind you first, a failure to respond is deemed a denial of the request and a violation of FOIA. This is one of the reasons I remind people it's a good idea to respond to everybody, because even though technically someone out of state doesn't have FOIA rights, they might read that and say, well, I'm going to sue because you never responded to me if you don't respond at all. And they'd probably lose because they don't have FOIA rights and they can't enforce FOIA against you. But why get dragged into court over something even if they're going to lose? You don't want to deal with that. So always respond to people. There's another question here. Does the information have to be printed, or can a requester be asked to come in and view documents? Again, this is the requester's choice of whether to inspect records or to get copies. So it's up to them. And if they agree to come in and just look at something, that's fine. If they want you to send copies, though, yes, you're required to send copies, is the general rule under FOIA. Next bullet point on the slide, creation of new records is not required. This is something comes up a lot. I had one the other day where somebody said they had a request for screenshots of somebody's email inbox. And I said, do we have to do that? And so I asked him, is this something you regularly do normally? And I said, no. And I said, well, no, that'd be creating a new record, I think. You don't have to do that. On the other hand, I'll mention as a tech issue, I've heard of some people with email archive software where it does take a screenshot of the email inbox on a regular basis. And that's part of what it does just in the course of business. If you had that going on, then yeah, you would have to turn those over as something you've done in the transaction of your public business. But if it doesn't already exist, you don't have to create it. My personal favorite example of this one is I was a psych major in undergrad, and there was a theory about the weather and violent crime. And it's as the heat goes up, so does violent crime up until a certain point where it gets too hot, and then violent crime drops dramatically. The reason being people get so hot, they go inside. There's no more interactions. And of course, when they're hot, I forget, it's 95 degrees or something. They get hot and irritated and people's tempers flare, but then over 100, it drops back down and people go home. Well, let's say you wanted to study that, maybe you're a psych grad student or something. And so you go to the locality and say, well, I want to get a map by neighborhood showing the crime statistics over the summer months along with temperature data. Can you do that for me? And I'll tell you, I always ask, has anybody done that? And if you have done that, please put in chat that you have and let us all know. But I'll tell you, in 16 years of doing it, so far I've only had one public employee say, yes, they actually make that map, because that is a real theory. But normally, most people don't do that. And so what you would do is you tell them, well, we don't have that map, but you can go to the police and you can get crime statistics by neighborhood. You can go to the GIS mapping people and get maps by neighborhood. Maybe, maybe not. You have weather data. More likely you have to go to NOAA or the National Weather Service to get the actual temperature data. But then once you get the records that already exist, they can put it together themselves. You don't have to do it for them. I would mention on the GIS mapping, this is an example where my understanding, We've had people testify from the Virginia Base Mapping Project and others that most of the GIS map data, the fundamental stuff, is already in the systems. It's available. And so GIS software is used to punch in the coordinates of a map that you want. It then converts the raw data that already exists into a visual form of a map. That is actually the conversion of format, not the creation of a new record. That can be a little tricky. It's something to talk with your tech people about if you ever have issues like that. But the general rule, again, creation of new records is not required. Question here, is there a specific format to respond to a FOIA? No, there's not, but we'll get into that a little more in just a minute. Last bullet point on this slide, just to remind everybody, as we said with the policy statement, you are always allowed to make agreements with a requester about the production of records. And my creating new records is an example. Sometimes you might say, hey, you know, rather than go through thousands of existing records and redacting each one to produce it, it would really be easier for me to pull the one data point that this person wants and make a new spreadsheet with just that and give it to them. And it might be that you can save yourself time and money and effort by agreeing to produce something that doesn't exist. And that's why FOIA says you're allowed to do it, but you don't have to do it. All right, turning to the 5 responses, and this is where I'm going to get a little more about format of responding. Your number 1 is provide the records. Number 2, withhold them entirely. Number 3, provide part and withhold in part. Number 4, tell them you cannot find the records or they do not exist. In other words, we don't have it. And number 5, we need more time. So when responding, if your answer is number 1, you're going to give them the records. That is all you have to do. You don't have to do anything else at all. You just say, here's the records. Some people ask me, well, what about a cover sheet? Don't you have to have a cover sheet about, you know, here you've asked for these and we are responding, we are replying, blah, blah, blah. You can, if you want to send an email or type up a letter and stuff, but I remind everybody, consequence of choice. If you create a cover sheet or a cover letter to respond to a FOIA request, I happen to know from the Library of Virginia, there's a 3-year retention period on that. So if you do that, it's not right or wrong. It's fine if you do, but you have to keep it for 3 years. That's the number for the number 1. For number 2, 3, 4, and 5, all of those require a written response. So for those ones, whenever you're saying anything other than here have the records, then you do have to do it in writing and you do have to keep it. If you're withholding stuff either entirely or in part, you always have to cite the exemption or the prohibition that either allows or requires you to withhold the records. You always have to identify the subject matter you're withholding. And if you are withholding things entirely, you also have to identify the volume. If you're withholding stuff in part, you don't have to identify volume because it's usually obvious what's missing. This is typically something where, you know, like names or social security numbers or something like that has been blacked out of a document and they can look and see that it's not there. With the number 4 response, requested records could not be found or do not exist. This again has to be in writing. And if you know that some other public body has the records, then you do have to provide contact information for the other public body. A typical example of this is something like somebody has a police chase that crosses jurisdictional lines, and you go to one sheriff or police station and say, hey, can I get the records of this arrest? And they say, oh, we didn't actually make the arrest, the neighboring jurisdiction did, so go to them. The last one for more time, I want to break this down a little bit further and just talk about timing in FOIA in general. We started with 5 working days, so you always have those 5 working days to respond. If that is not enough, you can invoke an additional 7 working days. To do that, you have to do it again in writing. You've got to do it within the first 5 days, and you have to say why you need the additional time. That'll give you a total of 12 working days time. If that is not enough, the next step, again, we mentioned negotiating with the requester to reach an agreement on the production of records. That's the next step, is you talk to them. It used to be that we would tell you that's pretty much the end of it because nobody ever got to the step after that. Unfortunately, it has happened a few times now where people could not reach an agreement on production of records. And so they go to the next step, which is to petition a court for more time. At that point, you're filing with the court and it's up to the court to decide what to give you. So again, you get 5 days. You can always get 7 additional days. After that, you have to negotiate. And if you can't reach a deal, you can petition a court. All right, talk a little more about exemptions and redaction. Again, exemptions and prohibitions are not the same thing. Exemptions meaning you can withhold it, but you don't have to. I'll give you a real example. If you go to hire a new police chief or a new county administrator or new school board superintendent, anybody like that, a CEO, almost every single time you release information that is protected personnel records, because you're going to tell them this person is good. They got educated here. They have a degree in this. They used to work here. They achieved this in their prior position. You talk about all the good things that are like gold stars on the resume, and you voluntarily release that information, even though technically almost all that stuff is going to be personnel information that could be withheld. But you want people to know that you're hiring a good person as your CEO, so you put it out there. Same thing is true if you look at any of the state schools and you look at the professors, you'll find their curriculum vitae, usually listing stuff about their education, the projects they're working on, their publications, all this stuff that would be personnel records, but they voluntarily choose to put it out there. Next, keep in mind, FOIA does have a redaction rule. This is to state that you can only withhold an entire record if everything in that record is actually exempt. And you can only withhold those portions which are exempt. So if you have a record that's mixed, you have to release the part that's open, but you may withhold the part that's exempt or prohibited. Again, typical examples, I mean, something, names and social numbers. If you have bank account records, you can withhold the account numbers, various things like that. So we have, we'll get to in just a second, there are going to be more examples of that. But first, charges. This comes up a lot. We get a lot of questions about charges. I want to read this line. This is from 2.2-3704, subsection F. It says, public body may make reasonable charges not to exceed its actual cost incurred in accessing, duplicating, supplying, or searching for the requested records. Every word of that sentence is important. When we talk about a public body may make reasonable charges, that may is important because it's permissive. You do not have to charge. You're allowed to charge. You do not have to. Okay. We sometimes see people make requests and say, please waive all charges because, and then usually we hear, I am a reporter and this is a matter that's in the public interest, or I'm a student and this is for an educational purpose, or sometimes because I'm an indigent person and I just can't afford it. Now, all of those may be valid reasons not to charge somebody, but up to your discretion here in Virginia. In other versions of FOIA, and I understand federal FOIA is the #1 example that we see this from, they have actual waiver provisions that say you should waive the costs in these situations. We don't do that in Virginia. We do not have waiver provisions. We just have this word may. So it's permissive. It's up to you to decide. You can take those things into account, but in the end, it's your choice whether to charge or not. And also keep in mind, sometimes people ask me, well, is there a set rate? No, there isn't a set rate. Is there a set minimum? No, there's no set minimum. But can you make one? Well, yeah, in the sense that sometimes people say, well, you know, the first $10 are free, or the first $20 are free, or the first 15 pages, or 30 pages, or whatever you want it to be. Some people have said the first half hour of work, or the first hour of work. I've heard it done a number of different ways. If you want to set a policy on that, about how much you will do for free, how much staff time, how many pages, that kind of thing, you may do so, again, because this is permissive. It's a permissive may. Keep in mind, though, charges always have to be reasonable. For those who are not lawyers and have not heard me say this before, reasonable is a legal term of art. Law school answer is usually, you know, what is reasonable? It is what is reasonable to a prudent, objective person, given the facts of any situation. From a legal perspective, if there's a dispute of fact, the only way you're going to get an answer to that is if you end up in court and a judge tells you what the facts are. Because of that, I'm probably never going to tell you, yes, that is reasonable, or no, that is not reasonable. I'm usually not going to go there because that's a judge's role to rule on what is reasonable. I will tell you, you know, put something in a ballpark figure and put yourself in the other guy's shoes and think about it, and you'll probably be pretty close. There are a couple examples I can give you of things that I think just about everybody agrees are not reasonable. But I'll never say absolutely one way or the other because that's a court's thing. What I can tell you, though, is the next part, not to exceed actual cost. Well, actual cost is something you can compute. And I know Phyllis has testified in committee before about this. You know, there's always things that are lost. There's that you're working for 3 minutes and then you get a phone call and then you go back to your FOIA thing and then your boss calls you in the office or a coworker or something for the staff doing the work. So you never quite catch everything, but you can still get a much better, not, I don't want to say estimate, but a much better tally of what the actual costs are than you can know what is reasonable. So I always advise, just make sure you're within actual cost, and then at least you have a colorable argument for whatever you're going to charge. When we get to the next part, the cost incurred in accessing, duplicating, supplying, or searching for the requested records. A few things going on there. One, this is where I talk about the funnel analogy. First of all, you're going through this whole process, and the Supreme Court of Virginia called it exclusion review. They upheld a trial court's decision in American Tradition Institute versus University of Virginia, 2014, that says you are allowed to charge for that whole funnel process where you're narrowing things down to what are the requested records, you're sorting those out, finding those records, and then reviewing them to make sure what's exempt and what's prohibited from release, and then releasing the stuff at the end. That process you're allowed to charge for. People always ask, can you charge staff time? Yes, you may charge for the staff time of the people who actually did the work. When we look at these elements, accessing, duplicating, supplying, and searching, okay, keep in mind paper records and electronic records are kind of two different worlds. We're much more in the electronic world these days, but the paper world is still out there. Accessing in a paper world usually meant flipping open a file cabinet, maybe going into a different desk drawer, sometimes going down to the basement into some storage facilities or even an offsite storage facility. With the electronic world, best example of an access fee I've heard is probably pulling a backup tape or some sort of archive or something. For older records, say you have records from the mid or late 90s that were electronic. Somebody wants something that you may not have a compatible program to even read those records anymore. You may have to get IT staff to search an old hard drive, pull up, oh wow, that was on Windows 98 or Windows 95, or that used some sort of proprietary format software we don't have, and how do we pull this? Those are the kind of things which can result in access fees just to get a hold of the record. Duplicating and supplying, this is where paper world is pretty easy. You can actually calculate the cost of a sheet of paper and toner cartridge and a stamp and an envelope or a banker's box and a shipping fee, all that kind of stuff for duplicating and supplying. Whereas the electronic world, most of the time that stuff is nominal. Usually you're talking about either cutting and pasting or attaching something to an email and hitting send. Sometimes loading a file onto Dropbox or a file transfer protocol site or something and letting people download it, or posting it to your website. Usually the fees involved are nominal with that stuff. Not always though. Sometimes there is quite a bit of time involved. Sometimes with supply costs, some files are just too big and you have to put them on a flash drive, and then you have mailing costs and the cost of the drive itself. Those are things to factor in. But the big one for both paper and electronic tends to be searching for the requested records. And here I'm going to talk again a little bit about the consequence of choice, and I'm going to date myself as being older than most people think I look, because I learned to type on a mechanical typewriter. And when I had to do a correction, I used whiteout. This was back in the 80s. I didn't type much because of it. I didn't like typing. Most of my friends didn't like it. We did it for, the report at the end of the year where the teacher required it to be typewritten. But other than that, we didn't use typewriters for much of anything. Whereas these days, people thought, all right, there's a me too. Thank you. I'm not the only one. But, for most people now, you got your phone, you got a computer, a laptop, whatever. People shoot off text messages all the time, instant messenger type stuff, emails. And then, of course, we have the whole world of social media. So we have tons of different forms of records that are just ready to hand, and we use them all the time. Nothing wrong with that. It's become very convenient. It's helpful in a lot of ways. But when it comes to searching for records, it just means there's pretty much an astronomical volume of stuff out there. And it makes it a lot harder and a lot more expensive to search through things. I have heard some horror stories of somebody said, oh, I'll give you a real one. I want some records from one county about the Mountain Valley Pipeline. This was Franklin County a couple years ago. And there was a citizens group interested in the pipeline, and they asked for all the emails and other records about the pipeline. I forget the time period, like a 2-year period maybe. Yeah, difficult to track and retrack. That's also true. But they asked for that, and they got an estimate, I forget, I think it was $3,000 something. And they said, wait, what? That's crazy. How can it be that much? And when I talked to people at the county, and I was actually interviewed by a reporter, so there's an audio interview of me out there somewhere on the web of this, what they said is because of the way the request was phrased, it was going to require all of the county employees, which they said was about 350 to 400 people, were going to all have to search their emails for anything to do with Mountain Valley Pipeline. And that search cost, of course, when you think about 350 people searching all their emails, even for just one keyword, yeah, that's going to take some time, and that's going to raise the cost tremendously. Now, this is another example of negotiation with the requester where they reached an agreement and they sorted out, hey, we don't really need to have everybody do it. Let's get the people involved in the project, the higher level people, and we sorted it down. And I think it was still a couple $100. There was still an expense involved because there was still quite a bit of stuff to do, but it was much narrower and much less expensive. So this is, again, to remind people, and this is something over years of experience, communication is key to a successful FOIA request. You can always negotiate. It's part of the policy from the outset. So anytime these default rules are not going to work for you, talk to the requester and make rules that'll work for that transaction. I tell you, we have it's actually one of our published opinions, I think, out there, where somebody's response was, oh, well, we can't do it, but you can get that done down at Frank's office. And that was part of their formal FOIA response to somebody. And we said, well, what is that? I have no idea because I don't know who Frank is or anything. Well, it turns out, if I remember right, they wanted oversized architectural blueprint copies that were done full size, and the government did not have that copier to do full size architectural blueprints. But Frank, who everybody involved knew who Frank was, he was an architect who worked down the street, and he did have that copier. So that's what they were talking about. But it's things like that where you want to be very clear in your communications, and you can make the agreement that'll fit the transaction. So always keep that in mind. All right, going back to charges. You can never charge more than the actual cost to the public body. So keep in mind, actual cost is always your upper limit. And the next part, this is a little bit new. Requesters requesting an estimate in advance and public body requiring an advance deposit. Those provisions have been in the law for years, but they were amended this year to make them a little more effective and a little clearer. I'm going to read you from 2.2-3704 sub F, the part about estimates. It says all charges for the supplying of requested records shall be estimated in advance at the request of the citizen. It said that for years, but it didn't have anything else. It didn't say anything about stopping the clock or giving you a chance to negotiate. So that's the part that was added this year. It says the period within which the public body shall respond under this section shall be told for the amount of time that elapses between notice of the cost estimate and the response of the requester. So when you send them that estimate, that stops the clock until they respond to you. It also says that if they don't respond within 30 days, the request is deemed to be withdrawn. Now, this kind of matches other language that's been in the law about advance deposits for quite a while, where it says anytime you estimate the costs are going to go over $200, you can basically stop the clock by sending them an advance deposit letter that says, we estimate the cost to be, and then whatever your total estimate is, please remit that amount. And then once they pay you, that starts up again. The change made to that section, it used to say the requester agrees to pay. Now it just says to pay because there was confusion over whether it meant they'd simply say they're going to pay or whether they actually get you a check in hand. Now it's clear, check in hand, some sort of payment. We got another question in chat. What do you do when you get a FOIA request from someone that's trying to stop you from governing or ruin your reputation? What is your course of protection? It's going to be outside of FOIA, honestly. With FOIA itself, I've heard numerous horror stories over the years about people abusing FOIA or using it for a purpose other than to, just get information to which they have a right, which is the purpose of FOIA. I'll give you my personal example. I talked to a gentleman one time years ago who was down in the Tidewater area, and he, after about a 45-minute conversation about his FOIA request, he told me, yeah, I'm just trying to think of as many possible ways to ask these questions and as many possible things to ask for. And then my neighbors and I are going to try to swamp our locality with all our FOIA requests because they're talking about base closure. And if they close the base, it's going to ruin our property values. So we're hoping to swamp them with so much other work that they miss the signing deadline. Okay, so I had a guy actually tell me that. Now that, and I told him, well, that's not what FOIA is for. That's not the purpose. But the FOIA provisions to deal with that are things like the timing provisions, where again, 5 days plus 7, negotiate with the requester. If you can't reach a deal, petition the court for more time. There's also, when they're doing stuff like that, that's going to be a huge volume of records, and it's probably going to be very expensive. And again, this is where you can demand the advance deposit up to the full amount of your estimate. I do encourage people with those estimates, I encourage you to go ahead and ask for whatever your full estimate is. I've heard people say that because the dollar threshold in the law is $200, they're only going to ask for $200. And I say to them, well, what if your estimate is $5,000 and that's a legit estimate and you only ask for 200? So they say, okay. And they pay the 200 and then you give them $5,000 worth of records. You do $5,000 worth of work and they take off. Are you going to end up in collections for the other 4,800? Yeah. Will you get it? Maybe, maybe not. But why put yourself in that situation when the law allows you to ask for the full amount? I'd go ahead and ask for the full amount. Other people have said, well, I just asked for half up front. And I said, well, why? Why half? And they said, half now, pay now, and then the other half later when you get the records. And I say, that's nice, but the law allows you to ask for the full amount. So go ahead and do it. Protect yourself that way. I have also heard horror stories about people. I think the last one was a gentleman told me it was a county attorney. He got a request and it was a whole lot of work, but not a whole lot of records. The request came in on letterhead from a nonprofit agency, and they made an agreement and said, okay, we'll have those ready, probably in a week or so. And so they made an agreement on it. They did the work. He said it was about $1,200, most of which was search costs. And there was just a little bit, I think he said maybe $50 worth of copy fees. They had a stack of papers ready for the guy, and the guy never came back. But a month later, he got an identical request on the same letterhead, but this time from a woman. And he said, part of it, she then said, I understand you already have these records ready, so I'd like them at cost of copies, please. So they were trying to jip him out of basically, I think it was about $1,150 worth of search costs. That attorney told me he wasn't going to do it, and he was going to take him to court if not needed, but I never heard back from him. So as far as I know, they were out over $1,000 of work that they did and never got paid for. Don't put yourself in that situation. The other thing about it is it protects the requester too. I had somebody recently contact me that didn't mean to do that. Sorry. They asked for records and they were charged, I think it was $379. And the public body apparently did not give them any advance warning. They just said, here's the records and here's a bill for $379. Technically, I guess you can do that under law, but it's not fair. It's not a good idea because he immediately said, I'm not going to pay that. You should have told me up front. So it sets up a dispute with that. So anytime you've got those big charges, go ahead and ask for that money. Do the advance deposit letter. We also recommend send that 7-day extension letter because those things are almost always going to take a long time. So go ahead and do that and offer to negotiate. Usually people will work out a deal. Now I see there's another question in chat. Let me scroll up a little to get that. What about a public committee and the chair and vice chair authorize the attorney to do request on various board members and the results are delivered to the board? The board never voted, authorized the committee to do these FOIC requests against members of their county. Interesting. I would just keep in mind, as far as FOIA is concerned, somebody who is a public employee or a public official, as long as you're still a citizen, you still have FOIA rights. I understand there was a case very recently. I haven't had a chance to read it. I just read about it this morning where a judge talked about some of this. We've got a couple opinions out there where we say, you got elected to office, great, congratulations. As an elected official, you may have additional rights that aren't under FOIA. Things like when you're going into a closed meeting as a member of the body, of course you have a right to go in where a normal citizen doesn't. At the same time, if you're requesting records from somebody, most of the time, there's not necessarily any specific law that covers it. So you still can make a FOIA request as a citizen, but generally when public officials and public employees are dealing with each other with record stuff, it's usually professional courtesy. There are some specific exchange of records laws out there. One of the ones that comes to mind is things about the police notifying school superintendents and principals about students who are convicted of violent crimes, things like that. I mean, they have some record sharing provisions out there, but for the most part, stuff isn't necessarily covered in a statutory thing. So I'll tell you, talk to your attorney about that stuff, about whether there is a statute for any particular transaction. Yeah, FOIA call. I'll have to turn that off. I'll call him back in just a minute. Yeah, it's something that FOIA says, if you as a member, say, of the county board want to request records from your county, you can do so as a citizen. Even though FOIA says you don't have to mention FOIA and you don't have to put it in writing and everything, I always recommend in those situations, because it can be confusing, that if you mean to make a request as a supervisor or as a board member or something like that, You probably should say so. If you mean it as a FOIA request as a citizen, again, you probably should say so just for clarity, because sometimes people say, oh, this is just a request from the supervisors. Also, part of your question here, again, I'm going to defer to your own attorney on this, but as a general rule, most boards act as a board, and they usually act by motion and vote. So if it's a board action and board authority is required, typically, yeah, it's going to require a motion to vote by the board. On the other hand, I've seen things where boards have said, we are going to delegate authority to one member, to the chair, to some employee, whoever it is, to do this, whatever the action is. If you've done such a delegation of authority, I can't say what your authority is to delegate authority and how much you've delegated in any particular situation. So again, those kind of things, if that's the essence of the question, I'm definitely going to refer you to your own attorney. Okay. Next one, any defense strategy or recommendations for nuisance or chronic FOIA-ers? Yeah, be nice to them. Honestly, be civil, be nice, and keep in mind that they can't violate FOIA by making requests, but if we fail to respond properly, we can violate FOIA. We on the government side are the only ones who can get in trouble. And I like to use two fists hitting against each other as my symbol for this. People kind of headbutt each other. They get mad at each other. They get ornery. They get obstinate, and they don't want to cooperate. And it can be on both sides. I've seen it from government people. I've seen it from the citizens. It can be with reporters sometimes. It doesn't pay for anybody. It doesn't help you. We used to ask people when we did live trainings, has anybody ever gotten somebody so mad that they went away? And occasionally people would say, yeah. And I said, and so then what happened? And usually they come back with a whole group of angry citizens who are now forming a coalition, a committee, a citizens group, whatever they call it. And you have a whole lot more people mad at you and making more requests. And it just blows up into an even bigger problem. I will tell you, I've had one person say that they did get someone to go away and stay away. But he said, but it was not when he was in a public office. He was working in a private library, and he got somebody kicked out and got a trespass order against them, so they couldn't come back. So that's a different situation. That's not where most of us are most of the time. Best thing you can do is be nice to people. Now, every once in a while, it's rare, but I've heard of somebody going, just straight up, they're going beyond FOIA. They're making threats. They're practicing physical intimidation. I remember one years ago from a woman who worked at the front desk of her public body's office, who, she told me she was about 5'2" and I think 100 pounds soaking wet. And they had a guy who was coming in who was 6.5 feet tall, weighed over 300 pounds. And he liked to lean over her and over her desk and shake his finger in her face while he was making requests. And it got to the point she was scared for her safety. And I said, at that point, don't call me, call the police, call the sheriff. If you get somebody who's, taking those actions that are just beyond a FOIA request, I'm not the person who can address that. That if it goes to the level of harassment, call law enforcement, call your attorney for that stuff. Next one, let's see. The authorized lawyer used public funds, paid him to go this on member county board members. Yeah, I mean, that again, I'd have to refer you to your own attorney. Possibly, I see Phyllis is nodding her head, so possibly, call somebody who's got expertise in local government law and, what level of authorization and delegation of authority you can do and then what actions they can take after that. Next one, is there any collection authority for unpaid FOIA requests other than refusal to respond to any future requests? Well, thank you for bringing us back to our bullet point here. If a bill goes unpaid for 30 days or more, you do not have to respond to any future requests. So that is the statutory provision in FOIA that says, if they don't pay the bills, you don't have to answer new requests. But of course, it's a debt is a debt is a debt. If you need to send it to collections, send it to collections like anything else. Generally, probably you're going to general district court on some sort of small claims effectively. But yeah, it's just debt collection. There's nothing special about it. Okay, moving to the next slide. Are there any more questions about charges? Let me ask that and give it a second. Okay, actually, I do want to mention something we hear fairly often is about flat rates, minimum fees, averages, that kind of thing, for the hourly rate for staff that does the work. please keep in mind, we're talking about the charges to the public body, and we are always limited to actual cost. For that reason, if you have multiple people who might be responding to a request and you want to set a flat rate, our advice is always to use the minimum paid hourly rate for that. Because the danger is if you use an average rate or one of the higher rates, and then a lower paid person does the work, that would exceed actual cost. So make sure you use a minimum rate if you want to set a flat rate. Okay, moving on. These are some examples of exemptions of general application. What we mean by that, first, keep in mind again, exemptions means these are things you don't have to release, but you may still choose to. General application is as opposed to specific application. Most of the exemptions in FOIA are specific as to the type of record and who can use it, which public body is allowed to use the record. These ones are general in that any public body can use them. They're only specific as to the types of records. First one, of course, we already mentioned a little bit, personnel records. General rule is you do not have to release records that concern identifiable individuals as personnel, except that you have to give it to them as the subject. And then there are also certain exceptions for things like their name, job position, salary, rate of pay, etc. Next two are going to be involving your attorney, so attorney-client privilege and legal memoranda and work product. For most of those, I can talk to you about them generally, but I'll tell you most of the time when people ask me questions about that and they start getting detailed, I remind them that those are things that they can waive the privilege by sharing it with someone outside, and I am not your attorney, so I will encourage you to contact your own attorney when you have specific questions about attorney-client privilege and work product. Next two I mentioned together, contracts and procurement. These are very similar, but significantly different. The contract negotiation exemption listed there is specifically for things that are not under a procurement act. The way it works is that you can protect records that would jeopardize your bargaining position or negotiating strategy up until the point the contract is awarded. Once the contract's been awarded, everything becomes open. The procurement exemptions are similar. There's one for the Public Procurement Act. There's another for the Public-Private Procurement Acts. They are worded, again, similarly but different. They have certain timing provisions when you release things to the bidders or offerers involved in the transaction. And then when you release stuff to the general public, they have provisions that if you don't award a contract, you can withhold the records. And the biggest difference, they have certain provisions to withhold records even after the contract's awarded, specifically for proprietary records and trade secrets. Those, you probably guessed, can get fairly complicated. So if you have any questions about procurement or contract exemptions, please give us a call, shoot us an email. And then the last one I already mentioned also, account and routing numbers. This is for any account and routing numbers for credit cards, bank account statements, pretty much any account with a financial institution. Generally, things like the balance sheets, accounts receivable, invoices, that kind of stuff is generally open. Accounting records are generally open. This is just to protect the account and routing numbers themselves. Personnel contracts exempt until ratified. Yep, personnel contracts generally are, you could use the regular contract exemption. They do have a special provision in the personnel records exemption though. Specifically, it says no provision of this chapter or any provision of chapter 38 shall be construed as denying public access to contracts between a public body and its officers or employees other than contracts settling public employee employment disputes held confidential as personnel records under 2.2-3705.1. So typically things like the standard employment contract would be open, but an employment settlement contract would not be open. That you can still withhold. Jumped ahead, sorry. And there's another one in chat here. This has been most helpful. Oh, well, thank you. And then second, the subsequent request for records. Does the original perhaps high cost for retrieval count, or does it become the minimal few minutes of mailing costs? That depends on, for example, if I went in and said, I want such and such records, can you get that for me? and you say, yeah, we'll have that for you next Monday if you want to come pick it up. What do you prefer? And I say, sure, I'll come in and pick it up. And I go in, pick it up, and I say, do you have the records I wanted on, blah, 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 blah. And you say, yes, here they are. The total charges were $90. 60 of that was for search costs and 30 of that was for copies. And the person in line behind me says, hey, could I get a copy of those too? Well, you already charged me for the search. That actual cost has now been paid. You've got the records right there. All you have to do is run off another set of copies. So for them, it's going to be $30. For me, it's 90. For them, it's 30 because those are the actual cost limits. On the other hand, if you had given that to me and then 3 years later, let's say you put all the records away back in storage, wherever they go, and somebody else came in and made the same request 3 years later, and you had to do the search all over again, then yes, it would be legitimate to charge again because you actually have to do it again. Okay, moving to meetings. Because yeah, we got plenty to cover, and we're taking good time on this, taking our time, going through it in detail. Okay, meetings, policy. Again, keep in mind, all meetings are supposed to be open unless you have an exemption that allows them to be closed. We're going to talk about the definitions of public body and meeting. We're going to go through the open meeting procedures and closed meeting procedures. And then we're going to do a little bit on electronic meetings. I don't want to go too in depth with that because it gets very complicated. But to start with, what is a public body? The first thing, of course, is all the things you would expect to be public bodies, including, boards of supervisors, EDAs, etc. The second one is a little more interesting here. Any committee, subcommittee, or other entity, however designated, I'm going to stop there. However designated means we don't care what you call it. It can be a work group, a task force, whatever. Of the public body, created to perform delegated functions of the public body or to advise the public body. So anytime you set up committee, subcommittee, or other sub-entity, a child public body, that thing is a public body in its own right. If it is set up by a public body, either to perform a delegated function or to advise the public body. Where this can be confusing sometimes, every once in a while we'll see something like a county administrator sets up a citizens group to advise him on proposed redistricting of some area or a rezoning plan or something like that. Or, maybe you've got a controversial store that wants to build a distribution center in your county or something like that. And some people like it, some people don't. And so let's say your county administrator gets 5 citizens together just to get some perspective and advise him. That thing is not a public body because it's only advising him as an individual. Whereas if the Board of Supervisors appointed the exact same 5 people to advise the board, then that entity would be a committee, subcommittee, or other entity of the board created to advise the board, and it would be a public body. So that's an important distinction to keep in mind. The other thing about that is the number. We've opined that a single person, occasionally by operational law, a single person is technically a public body in some ways, but as a general rule, when we're talking meetings, it's got to be more than one person. Otherwise, you're talking about people, staring in a mirror and thinking out loud as the meeting, and that's crazy. So we don't consider one person to be a body, but 2 or more can be. Definition of public body also includes other organizations, corporations, or agencies in the Commonwealth supported wholly or principally by public funds. This is typically tax-exempt organizations, maybe volunteer fire departments, area agencies on aging, various things like that receive public funding. With those, we look at how much of their funding is public. And we've said as a rule of thumb where it becomes clear-cut is 2/3 or more. If they got 2/3 or more, then absolutely they are principally supported by public funds and they would be considered a public body. I have seen at least one court case that went down to just about 50% for a tax-exempt organization and said, between what they're doing and the public money they receive, they effectively are acting on behalf of government. We're going to treat them like it and make them subject to FOIA. So it can be a lower amount, and it's always going to be a case-by-case, fact-specific inquiry. Last one, as I mentioned before, constitutional officers are included as public bodies, but only for records purposes. Please repeat that. There was a repeat that for which part? Was it the committees part and other entities? Advisory. Okay, so the second bullet point here, any committee, subcommittee, or other entity of the public body created to perform delegated functions or to advise the public body. So anytime you set up something as a body, and you say, okay, it could be, I'm going to appoint these 3 members of the board to become the finance committee. You go interface with county staff on finances and draft, some budget recommendations for us to consider, or something like it. Could be whatever. It could be the executive committee, it could be a personnel committee, a search committee. I've heard of the trees committee, anything like that. And I'll get to the next question in just a second. But any of those things that are set up by a board, a council, or another public body, one of these things listed in the first one, those are going to be public bodies themselves. So whenever, a board of supervisors creates a committee, a subcommittee, a task force, a work group, whatever you call it, and you give it a delegated function or an advisory function, that thing is also a public body in its own right. It is subject to FOIA. So always keep that in mind. With the next one, can you please explain why constitutional officers are not required to follow the same FOIA procedures as elected officials? Constitutional officers, again, this was a Virginia Supreme Court case from 2002 where they ruled that they were not public bodies, and then the General Assembly responded by including them as public bodies, but only for records purposes. And the idea there is again, it's pretty simple, really. The constitutional officer is the head of their office. They don't have a body to meet with. It's just them. So they don't have to be subject to the meetings rules. Normally, a sheriff, a court clerk, treasurer, that kind of thing, Commonwealth's attorney, they are the head of the office. They make the decisions. There is no deliberative body like there is with a board or a council. So what's the rule on recording public open meetings, maintaining those recordings as records? Jumping ahead a little with that, but there is no specific rule in FOIA other than if you record a meeting, then the recording of the open meeting is subject to FOIA as a general rule, as a record. As far as maintaining, my understanding from the Library of Virginia, but always double check this, is recordings, notes, anything else about a public meeting that you're using to draft minutes is usually why people keep them. Those things have to be kept until the final minutes are approved. If you're thinking of electronic meetings, that's a different issue, and I'll get to that in just a minute. But let me go on here. Definition of a meeting. Let's talk about that first. First thing includes meetings, including work sessions. So I like to just point out that is black letter law. Work sessions are meetings. I do periodically get people calling me up saying, oh, it wasn't a meeting, it was just a work session. By definition, a work session is a meeting. So keep that in mind. Then when sitting physically or through electronic communication means as a body or entity or informal assemblage. That part's important because you might be all of you at the dais or around a conference table, or it could be some of your members hanging out at the grocery store, looking at the heads of lettuce and the carrots and all that stuff in the produce aisle. It can be a meeting regardless, whether you're there formally or informally. We don't care about that. It's also important because the Virginia Supreme Court back in 2004 had a case, Beck versus Shelton, where they were considering email as a meeting. And the emails in that case had at least 4 hours between any email that was sent and any reply that was sent back. And they said because of that delay in time, they were not meeting as a body or as an assemblage, because that necessarily means there has to be, and they use the phrase, an element of simultaneity. So you have to be talking in real time because of that part of the definition. Next, we have the numbers clauses here. As many as 3 members or a quorum if less than 3 of the constituent membership. Got to read all that together. Everybody knows the rule of 3. 3 or more members together talking public business is going to be a meeting. However, the quorum if less than 3, well, that means 2. Because as we said, we did an opinion where we said we don't think one person can have a deliberative body meeting by themselves because they're just one person. But 2 people can. So that's where you have a quorum if less than 3. So if you create a committee, subcommittee, or other sub-entity, and you only put 2 or 3 people on it, then standard rule of quorums is that it's a simple majority. 2 people is going to be your quorum. Anytime those 2 people get together, talk about the business of that sub-entity, because it is a public body in its own right, that is a public meeting, and it's got to follow FOIA. Okay, so you can have situations where 2 people are having a meeting, has to be done publicly, notice to the public, all that stuff. Next part of definition, wherever held with or without minutes being taken, whether or not votes are cast of any public body. Again, this emphasizes, we don't really care if it's formal or informal. We care about are the people who are the members of the body getting together to talk or transact public business. Even if they're not voting, it can still be a discussion of public business and still be a meeting. Okay, and you see that in the next 2 bullet points, and on the next slide we have exceptions. The definition accepts certain things. Number 1, gatherings of employees. This is to point out the rules apply to the members, not to the staff people. Otherwise, employees are almost always getting together in groups of 3 or more, and everything would be a meeting. You couldn't possibly get it all done. Next, his gatherings where no part of the purpose is discussion or transaction of any public business. So this one, my example, you got your 3 members running into each other in the produce aisle at the grocery store. You know, they're there to shop, they're there to get food. They're not there for the purpose of discussing or transacting public business. That is not a meeting unless they turn it into one by just, you know, instead of saying, hey, you know, I'm getting lettuce and carrots. What are you here for? You go, oh, hey, you know that ordinance we're voting on next week? I think we need to amend. Yeah, that's going to turn it into a meeting if they start talking public business. The last exception here, public forums, candidate appearances, or debates, the purpose of which is to inform the electorate and not to discuss or transact public business. This is things like, let's say you call a town hall meeting with your constituents in your district, and some other members decide they want to hear what you have to say, and so they attend in the audience, but they don't participate. They're not speaking. They're just there to listen. Or let's say elections coming up and an incumbent has a challenger, they agree to a debate, they're up on the dais having their debate, and other members want to hear what both the incumbent and the challenger have to say, so they attend, and again, they're in the audience, they're just listening to what's going on. Those things are okay, they're within the exception. The danger, again, just like we used to call it the chance meeting bump into rule for the second bullet point, that third bullet point is if the other members are sitting in the audience and say, hey, wait a second, no, I think we got to do this. No, let's do that. And they start getting involved in the debate and all of the members start discussing public business, then they're going to turn it into a meeting. So you got to watch yourselves and practice some self-censorship, and keep in mind, wherever you go as a member of a public body, you bring your meetings rules with you. If there are other members there and you start talking public business, that can become a meeting. Okay, for the next, the requirements for open meetings, you got to have notice. It's got to be open to the public, and you got to have minutes. So the notice requirements, first notice, this is notice to the public. Notice to the other members is usually covered under your own statutes like 15.2. We'll get to straw polls in just a second. On decisions over email, nope. I'll just say nope. You can't vote by email. So you can do straw polls in a closed meeting, for example. You can express an intent to vote a certain way by email or straw poll, but it doesn't count until you actually vote in an open meeting. Let me go through this and we'll get to voting in just a second. For the notice requirements, notice to the public has to have date, time, and location of the meeting, and it's got to be posted in 3 locations. 1, official public government website, if any, and I understand that there was a court that recently ruled that means it has to be a .gov website. So this is something we'll probably bring to the attention of the FOIA Council and see what they think about that. The number 2, prominent public location in which notices are regularly posted. This is my personal favorite because it gives you some leeway. This is typically town hall, public courthouse, public library. It could be your local newspaper of general circulation because people are used to looking for notices there. My personal favorite was somebody who said, if I really want to get it to people, I'm going to put it on the corkboard outside a Food Lion. And I said, okay, the point here is to get it where people are going to see it. And then number 3, office of the clerk or chief administrator of the public body. And that's exactly what it says. For regular meetings, you got to post at least 3 working days in advance of the meeting, which means you do not count the day of the meeting as one of the working days. For special emergency or continued, you got to have 2 things. 1, it's got to be reasonable under the circumstance. So there's that word reasonable again, meaning only a judge can tell you yes, no, absolutely. Based on the facts of that case, it is or is not reasonable. But it also has to be posted at the same time notice is sent to the members. So that's something just like actual cost with charges. We can look, did you post it, same time you sent notice to your members? Okay, if so, you're within that part of it. Last, people can sign up for direct notice. Typically, this is done by email unless they object to email. And so almost everybody just has an email listserv of some kind where you send out notice of your meetings via the listserv. With next part, what does it mean for a meeting to be open to the public? It's actually defined, means where the public may be present. COVID-19 has kind of changed our understanding on a lot of this. just because we're looking also at, a virtual presence as well as physical presence, and it's necessary because of social distancing. So we've given it a fairly broad interpretation and encouraged everybody. You'll see at the last bullet point there, use whatever means you've got available to make it available to the public. Live streaming, broadcasts on local TV or radio, posting recordings, etc. These are all good things to increase public awareness. They're all, favored by FOIA. Next, you always have to allow the public to record, photograph, film, or otherwise reproduce your meetings. And FOIA says you cannot meet anywhere where the recording equipment is not allowed. You can tell people where to place the recording equipment so it does not interfere with your meeting. So, if somebody came in with a full-size TV studio camera, those things are big, and they want to put it right in front of the dais, you could probably say, no, sorry, it's going to interfere with everybody else's view, so put it off to the side. But you couldn't tell them put it out in the hallway, then they couldn't record. Third bullet point, this has come up a lot with COVID-19 as well. FOIA doesn't address your logistics, things like room capacity. We've had people say, given social distancing of COVID-19, we can only fit 4 people in the actual room, besides staff and the members of the body. So what do we do? And that's where we go to the last part, fit as many people as you can given social distancing and the safety requirements from the health department and the CDC and all that. But beyond that, use as much other means as you can to increase public awareness of what's going on. For minutes, you only have to take minutes at open meetings, not closed meetings. They have to have date, time, and location, just like the notice did. They also have to have the members of the public body present and absent. And the best part, summary of matters discussed, deliberated, or decided. This is where you have some leeway and you can use your discretion as to how much detail to include. Generally, we tell people, it doesn't require a transcript, doesn't have to be verbatim because it says it's a summary. At the same time, if somebody spoke, we encourage you to make note of the fact they spoke. I'll tell you, one of our meetings coming up, we've received, I think we're up to about 50 emailed public comments on it. And so what we'll probably, we'll tally up how many in favor, how many against, and we've posted them all to our website. So we will probably do an included by reference. Go check the website for all of those, rather than try to reproduce them all or read them all into the minutes. So you have some leeway there. You do have to record votes taken, any motions to enter a closed meeting, and the certification afterward, which also requires a vote. I would encourage you, as much as possible, try to get your motions and votes in there verbatim and get them to be fairly exact, because otherwise there can be questions later. I have seen recorded minutes that were approved that had motions that did not match people's videos of what was actually said as the motion. So you don't want that to happen. You want to make sure everything matches up. So try to get those exact as you can. Back to the questions here. Let's see. Okay. If there are 3 or more supervisors sitting in on a meeting, not talking, learning, is this a meeting? Generally, no. If there's no discussion or transaction of public business by the members of the body, it is not considered a meeting. However, a couple things to keep in mind. One is just public relations and public perception. If they see 3 or more supervisors sitting around a table and their mouths move, they're going to probably assume you're talking public business, and it is a meeting, regardless of what's actually going on. You might just be talking about, how well or poorly a sports team is doing, whatever it might be, the weather that day. Your kid just won an award at school. It could be anything innocuous, but people are generally going to presume you're talking public business because those are the things they know you have in common as members of the same board. The other thing about that is, for example, if you have an informational session where the board members are just going to sit and listen to somebody else talk, technically it's not a meeting, but if the board members want to talk about it, they're going to need to discuss things, and it's probably easier to call it a meeting most of the time. Not always, though. We've seen situations, for example, where a board went on a tour of a Navy base. The Navy base had nuke submarines, and they weren't letting the public in. It wasn't going to happen for security reasons. So with something like that, or say you're touring a factory, and the owner of the factory doesn't want their competition coming in with the public, so they're not going to let the public in either. With those, we recommend things like call a meeting or announce that, hey, we are going on a tour. It's purely informational. We're not going to be discussing or transacting any business while we're there. And then when we get done, we are going to meet, and preferably same day if you can, at whatever time and location you know you can be there. You go to your meeting and then you discuss what you learned as part of the informational part, and you do that at the public meeting, and that way the public can be aware of what's going on. Let's see. Got straw poll or decision over email, not real time, considered conducting official business. It can be if it's treated as a vote. And then, is it necessary to save emails with info about an upcoming meeting and agenda? I would talk again to the Library of Virginia about the record retention on how long you need to keep something like that, because I'm not sure what the retention rule. It is going to be subject to FOIA as a public record for as long as you have it, but I'm just not sure what the retention rule is. Okay, agendas. The rule in FOIA about agendas is that you have to have at least one copy of the proposed agenda, and all agenda materials, unless they are exempt, that are furnished to the public body have to be available for public inspection at the same time they're given to the members. So if you don't hand out your materials until the meeting itself, just remember to have an extra copy of the materials to sit at the front table for the public to look at. If you send them out a week in advance, have that extra copy available for the public a week in advance. Usually on a practical level, most people post this stuff to their websites now, and the public gets it there. And that obviates the need for FOIA requests and saves everybody time and money, because people know, go to the meeting website, there it is. Keep in mind though, FOIA does not address things like agenda changes, the agenda contents or items, and parliamentary procedure. I've had people numerous times ask me things like, they say, oh, well, I don't think this motion for the closed meeting is good enough. Here, look in the agenda. This is what it says. And I have to tell them, well, that's the agenda. And FOIA doesn't talk about what motions you put in your agenda. We talk about the motions you make at the meeting. I want to know about the actual motion that was made, not the one that's in the agenda. That one doesn't actually, FOIA doesn't say anything about that. Again, people talk about changes to parliamentary procedure. They talk about things like, oh, they added a closed session item that wasn't announced. Well, FOIA doesn't require you to announce a closed session. So under FOIA, that's okay. But keep in mind, other rules, usually under Title 15.2 or 22.1, whatever specific to your body, they may talk about what you can or cannot do as far as agenda changes. If you have adopted Robert's Rules of Orders, for example, you're going to be following those, but that's not FOIA. That's under your own adoption of that. If you have bylaws, rules in your charter, stuff like that, for those, I'm going to always tell you, talk to your attorney about it. Closed meeting procedures, okay? We've got motion, discussion, and certification. First thing to do to close a meeting is always have an open meeting. You cannot have a closed meeting without having an open meeting first, because the first thing you have to do is take a vote on a motion. The motion has to have three things. It's got to have your subject matter, your purpose, and it's got to have your citation to the exemption. The Supreme Court looked at this recently. I believe it was Cole versus Smith County Board of Supervisors this year. And they said you do have to have all three of these things, and something we've been saying for years, but now there's a Supreme Court opinion on it, so that is controlling statewide. The subject matter has to be identified separately from the purpose. When you look in the law at 2.2-3711, subsection A, it lists out a little over 50 different purposes, but the first thing it says is public bodies may hold closed meetings only for the following purposes. So when you quote or paraphrase your exemption, you're identifying the purpose. You have to do something more than that to identify the subject matter. You don't want to be so specific that you're defeating your whole reason for having a closed meeting, but it's got to be more than whatever it says in the statute. Classic examples are usually, personnel is the first exemption listed. You're talking about specific individuals, and people ask, well, do we have to name them? Well, no, you don't have to name them, but you've got to say something more than personnel. If all you say is we're having a meeting, closed meeting for personnel purposes under 2.2-3711A1, that is not sufficient. If you are saying we're going to discuss hiring new administrative personnel under 2.2-3711A1, okay, now I know you're talking about hiring somebody. It's an administrative position, and here's my exemption. Now I've got everything. That's okay. But you do have to do that little bit, something more. For the closed meeting discussion, keep in mind you can only talk about things identified in your motion that are allowed to be discussed in closed meeting under FOIA. You cannot stray off topic. If you do stray off topic, that would be a violation. You don't have to take minutes. If you do decide to take some minutes in your closed meeting, it'll be exempt from FOIA, but keep in mind, again, this is kind of a consequence of choice thing. If you have written minutes of a closed meeting, and there's a challenge to it later, somebody might subpoena those minutes and you might have to turn them over. Even though they're exempt from FOIA, subpoena is a separate process. Also, there's special rules for who can attend a closed meeting. It says non-members can be invited if they're necessary or they will reasonably aid consideration of the topic. And it also says in situations where you've set up committees, subcommittees, or other sub-entities or child bodies, members of the parent body who are not on the child body can still attend the closed meeting of the child body, but they can't participate. So example of that, let's say you're hiring a new county administrator, you've set up an executive search committee, and you're not on it, but you want to hear what they have to say. And so you go to the meeting and you listen in on the closed meeting part when they're talking about the candidates just because you're interested. That's okay. But if you start participating when you're not a member, that's not okay. So you can only go to listen. Question. Okay, at the top of the screen it has 2.23712. You say 2.23711, which is correct. They're both correct. 2.2-3712 is the procedural section on closed meetings. 2.2-3711 lists out the exemptions and has a little bit of stuff, but both 3711 and 3712 address closed meetings. So they're both correct. Okay, going on with certification of a closed meeting. So after you have made your motion, you've held your closed meeting, had your discussion, you come out, you certify, you only discuss matters lawfully exempted from the open meeting requirements and that were identified in the motion. You have to take a motion and vote on that. There have been a number of situations over the last few years at local level, at state level, different public bodies where people have certified closed meetings and this is members we're talking about, so they voted to certify the closed meeting. And then sometime later came out, and usually they talk to a reporter is how we know about it. And they said, well, I think we did it wrong. In hindsight, I probably shouldn't have voted to certify that. I think we strayed off topic, whatever it is, or I think it wasn't a proper topic to begin with. It should have been an open meeting, not a closed one. We've seen a number of those across the state, different public bodies. Because of that, the General Assembly has added an extra penalty for improper certification. So please keep in mind, if you think something went wrong with the closed meeting, you're supposed to make a statement to go into the minutes about whatever it was that you think went wrong, and you do it before you vote. Okay, now we're on to voting. So this is where I'm going to get back to the thing about emails on decisions. It says all votes taken to authorize transaction of public business must be taken recording in an open meeting, and it actually says in a meeting conducted in accordance with FOIA. I will warn you, we haven't gone this far, but the Attorney General has said in a couple of different opinions that if the meeting was not conducted in accordance with FOIA, the vote would be void. They had one specifically where the notice was improper and they said all votes at that meeting would be void. And then another, if you look at the last bullet point, decisions made in closed meeting are not effective until the vote's taken in an open meeting. They had one, that provision says you have to identify the substance of the vote. And the Attorney General said they did not identify it sufficiently, and therefore the vote was void. As far as straw polls and consensus, you can do that in a closed meeting, but keep in mind it doesn't count until you come out and vote in the open meeting. It also says no written or secret ballots. So you can't vote by email because that would be a written ballot, and it would also be secret in that the public can't see it unless they come and ask for it. So votes by email do not count and would actually be a violation of FOIA. I know that's been challenged at least once in court. Okay, like we did with records, some commonly used exemptions. Personnel is the first one. It's been interpreted a little differently. It's worded a little differently in the meeting side than it is on the records side. But keep in mind, some of the stuff the Attorney General has said about it. You got to look at what it says and apply the words in that there are certain actions listed. Discussion, consideration, or interviews of prospective candidates for employment, and then assignment, appointment, promotion, performance, demotion, salaries, disciplining, or resignation of specific public officers, appointees, or employees of any public body. And it goes on from there. The AG has opined that if you're not doing one of those things about one of those people, you can't use the exemption. This is a point of contention sometimes because specifically the Attorney General told the City Council they cannot discuss city employees because their charter limited those actions to the city manager. So I can tell you some local government attorneys straight up disagree with that. Some of them have said, well, the easy workaround is you call in the city manager to discuss the city manager's performance and then ask them, why didn't you fire that employee? Other people have said they agree with the Attorney General and would follow that rule. So that's one of the ones, for example, I'm going to tell you, talk to your own attorney about that. Moving on, scholastic record students, that of course is for school boards. Acquisition or disposition of real property. I mentioned this is anytime you're dealing with real estate, purchase, sale, or lease. This exemption many years ago also talked about condition or use of the property, but they removed that from the exemption. So you can no longer talk about condition or use of the property in a closed meeting. You can talk about buying it, selling it, or leasing it, but not just repurposing it. Next one, discussion of prospective business or industry. This is where no announcement has been made about the business or industry's interest in the area. And so it's one where you're going to be necessarily vague in identifying your subject matter, because if you're too specific, that would be an announcement. So you're going to have to be vague on that one. Next two are usually involving your attorney. You've got actual or probable litigation. This one is consultation with staff or your attorney. So sometimes you could be talking about things dealing with litigation where you're not talking to your attorney, but typically they're usually involved in that. With the specific legal matters one, that one does mean consultation with your attorney, not just with staff. So your attorney's always involved in that. I would keep in mind, actual litigation is obvious. Something's been filed. Probable litigation is actually a defined term in FOIA. It means you can identify either who you're suing or who would sue you and what the matter would be. It is not just possible litigation. If you think that, oh, well, maybe somebody would sue us someday, that is not good enough for a closed meeting. Again, specific legal matters, similarly, it's got to be something specific. So for example, if you are negotiating a contract with somebody and you need to consult your attorney about an indemnity clause and the liability that might ensue from that clause and that language, that's a very specific legal matter. That's fine. Whereas if you're just saying, hey, maybe we want to enter a contract with somebody someday, what kind of things should we think about for that? What kind of terms? That would be general. That's not a specific legal matter. Next one, public safety issues. This is typically things like building security, cybersecurity, anti-terrorism kind of stuff. I mention it to keep in mind, every once in a while we get somebody, something criminal and controversial has happened in the locality, and maybe the sheriff or the police chief just wants to update the board or the council. Typically, there is no exemption for that, unfortunately. So that's not a closed meeting topic. Whereas if you're talking about, the actual security of a building or some sort of cybersecurity measures, anti-terrorism, that kind of stuff, that is a closed meeting topic. Last one here, discussion of award of public contract. I mention it because this has been interpreted by the Supreme Court as meaning contracts under procurement laws. And there are other exemptions usually for other things like, for example, the real estate exemption above. So if you have questions about those, please give us a call. Last little bit here, electronic meetings. The quick gloss over on this is there are now 6 different processes for electronic meetings. 5 of those are in FOIA, 1 is in the state budget language. For localities, you can use 4 of those. 1 of them is only for regional bodies, 1 is only for state bodies, so you can kind of forget those 2 if you are at a local body. Keep in mind 2, and these require that there's a physical quorum present first. You can do personal matter up to twice per year, or you can do a medical condition or disability that prevents attendance, and that is not limited in number. We currently have an electronic meeting subcommittee. Like I said, we've received a lot of public comment. They're looking at opening that up, particularly for people to take care of sick family members. But we've got a lot of comments about opening it up further on other ways. So that's stuff that the committee's looking at. We'll see if they make changes this coming session, and we'll probably end up continuing the committee next year, I suspect. For current law, personal matter or medical condition, both, like I said, require you have a quorum physically present. There has to be a participation policy in place, and the remote member's voice has to be heard at the main location, and personal matters is limited to twice a year. Of course, with COVID-19, nobody wants to have a physical quorum. So we look at the 2 other provisions usable. These are by any public body, including localities, are both when the governor's declared a state of emergency. There's one in FOIA, but it is limited to responding to the emergency. That is the only topic you're allowed to discuss. That was sufficient in the past because most emergencies were weather related. So people were talking about snowmageddon or a hurricane hitting the coast, and what responses are we going to do now? and it's used a couple times, maybe it's over in a few days, and you're back to normal business. Obviously, with COVID-19, this has been going on for months and months and months, and so they needed something that allows you to do regular business electronically without a quorum, and this is where we get the budget language allowing for that. I would recommend, if you have not done so, go to the budget. It's available on the Legislative Information System online. Look at item 4-0.01. Sub G is the actual language for this thing. Keep in mind it is a separate and additional way to do electronic meetings. It has its own requirements. One of the big differences, and I'm going to read this to you, a public body shall make available a recording or transcript of the meeting on its website in accordance with timeframes established in 2.2-3707 and 2.2-3707.1 of the Code of Virginia. So this is one place where it requires a recording or transcript. FOIA normally does not, but if you're doing the state budget language for an electronic meeting without a quorum, you are required to have that. Keep in mind, again, both of these can be used by any public body. The state budget language is for any purpose. The FOIA version is only to address the emergency, and you don't have to have a quorum or a policy in place beforehand. The question is, will this meeting be posted as a video later? And Phyllis has answered, it will be recorded and posted by VACo. Okay, continuing with electronic meetings. Do keep in mind, even if you can't participate because you can't meet whatever the procedural requirements are, you can still call in just to listen, or if it's audiovisual, to listen and watch. And public and staff can always participate electronically. These restrictions only apply to the members. This stuff gets more complicated than I just made it, believe it or not. And so we have a link to our electronic meetings guide for a more thorough discussion. And a note about FOIA and social media. Things like Facebook and Twitter and other stuff, they can implicate both the public record side, as we discussed earlier, and the public meeting side, because it is possible for 3 or more members or a quorum of 2 to discuss business in real time over social media. And so for that reason, keep in mind, you could be implicating both records and meetings anytime you use Facebook, Twitter, any of that stuff. We do have a guide on that as well, and I would keep in mind, there are going to be questions I can't answer. This is one of those situations where people start asking about, well, what about deleting posts, blocking users? Is social media a public forum? Are there freedom of speech rights that apply? Those are all valid questions, but they all fall outside of FOIA, usually under constitutional law. So I'm going to direct you to your own attorney for those kind of things. Finally, remedies and penalties. What happens if something goes wrong? As I said earlier, enforcement of FOIA is through the court system. The basic remedy is a petition for mandamus or injunction, which means the court's either going to order you to do something, mandamus, or not to do something, injunction. It's up to the petitioner to decide if they want to file in general district court or in circuit court. If they file in general district court, you get appeal, and appeal would go to circuit court. Appeals from circuit court for FOIA matters go up to the Virginia Supreme Court. The venue against a local public body is always in the county or city where the body is. It's where your jurisdiction is. And also FOIA says a single violation is enough to invoke the remedies. With the petition, they're supposed to have an expedited hearing within 7 days, but the petitioner has to notify the public body before filing. And if the petitioner wins, they're to be awarded court costs, attorney's fees, and any expert witness fees. And that is to be paid by the public body. Typically, this means that if you get sued here, the court is going to order you to obey FOIA. If you didn't do so before, they're going to order some sort of correction. And that in itself, for most people, is not particularly scary because it's telling you to do what you should have been doing anyway. But I'll warn you, the court costs can get pretty expensive with attorney's fees and all that. As an example, we saw a situation where a county board was sued over a meetings violation, allegedly. Started out in general district court, it got appealed up to circuit court, and went all the way up to the Supreme Court. And in the end, the county board lost and had to pay out, I believe, and this is, I want to say this was 14 years ago, they paid $93,000 to the other side's attorneys. My understanding is that the editorials then read on the weekend about how your county board of supervisors violates your right to know and wastes $93,000 of your taxpayer money doing it. Okay, so this is not the kind of thing anybody wants to read about themselves. So please be careful and try to not violate FOIA. Last bullet point here, public body bears a burden to prove an exemption. It makes sense if you think about it, because if you use an exemption, you have withheld a record or you have closed a meeting, and so the other side can't know what it is. because you withheld it. And so it's up to you to prove that it does apply and you use the exemption properly. There are additional penalties, as we mentioned earlier. The first set, this has been a FOIA for quite a while, for willful and knowing violations of certain other records and meetings requirements. The penalty there is $500 to $2,000 for the first violation, $2,000 to $5,000 for second and subsequent violations, and it is paid by the individual who is found to have committed the violation. It's paid to the state literary fund, so it does not get the requester rich, but it's not paid by the public body. It comes out of your pocket if you do that. We do have language in there that says you can introduce advisory opinions that you've relied on in good faith as evidence that it is not a willful and knowing violation. Next, we have not seen these imposed yet, but the General Assembly did add within the last couple of years additional penalties, first for the alteration or destruction of public records before the record retention period is up with the intent to avoid FOIA. If they find that violation, it's up to $100 per record is the penalty, in addition to other penalties, and it is again paid by the individual to the literary fund. It is not paid by the public body. This is another reason to check the record retention periods that the library sets to make sure you're not violating the Public Records Act. Next one, improper certification of a closed meeting. I mentioned this earlier. The actual penalty there is up to $1,000, but this time it is paid by the public body, not by the individual. Again, paid to the literary fund, and the court can consider mitigating factors of Attorney General's opinions, court cases, or published opinions from the council. And then the last bit is additional resources. So again, contact information for the FOIA Council. The Library of Virginia has all of the record retention schedules. And then we listed out the websites for the Municipal League, the Association of County School Board Associations, and the various groups that are for the constitutional officers. So all of that is there. That is the full presentation. So I'm going to stop the sharing here. Let's see if I can. There it is. Well, it doesn't want to stop. Let me see if I can try that again. There we go.
While Alan's doing that, if people have additional questions, they can go ahead and put them in the chat. And if Alan has a few more minutes, we can answer any additional questions.
Yep, happy to stick around if anybody has questions.
We'll just wait a couple minutes, but Alan, while we're doing that, I just want to say thanks to you from VACo and from all our members who are on today. And, you know, it's always helpful to have the interaction. And even though we're virtual, people have been remarking what a great job that you've done at responding to every question as you've been doing your presentation. And I have to say, I think it's been an excellent training session, and we're looking forward to posting it on the VACo website when we're done, so that if people need to review it, they can, or if people are having trouble getting on your website, Alan, that they can view the training in its entirety as well. I don't see any further questions, so let me say thank you, Alan, for being here and your time in preparing this, and thank all of you for hanging in and being in this training session. And I hope you all have a good afternoon and evening. Thank you.
Thank you, Phyllis.